She sued her doctor for $340K. The camera caught everything. She sued her doctor for $340,000. The surveillance footage told a very different story. For 11 years, the florist had built her business one centerpiece at a time. Silk ribbons, fresh peonies, late nights in a refrigerated van. She was the kind of vendor who remembered which bride hated eucalyptus and which groom was allergic to lilies. By the spring of her 12th year in business, she had 43 weddings on the books, a part-time assistant, and a reputation that stretched 3 counties wide. Then came the appointment that she claimed changed everything. The doctor ran a family practice out of a converted Victorian on the corner of Elm and Birchwood. He'd been seeing patients in that building for 19 years. His waiting room smelled like old magazines and lavender, and his staff turnover was almost non-existent. By any measure, he was considered a careful, conscientious physician, the kind patients drove 40 minutes to see. On a Thursday morning in late March, the florist arrived for a routine follow-up appointment. She checked in, waited, and was eventually led down the main hallway toward exam room 3. That hallway, she would later testify, was her undoing. She told the court she slipped on a wet floor. No caution sign, no mat, just a freshly mopped corridor in a doctor's office that, she argued, had failed its most basic duty of care. She hit the ground hard, left hip, left wrist, left knee. She said she heard a crack before she felt the pain. The diagnosis that followed confirmed a hairline fracture in her wrist and significant soft tissue damage to her knee. For a woman whose livelihood depended on lifting, carrying, and arranging, the injuries were catastrophic. She missed 7 weddings that spring. She lost $28,400 in direct revenue. And she claimed the trauma, physical and psychological, had permanently altered her ability to work at full capacity. Hence the $340,000 suit, which included medical costs, lost future earnings, and pain and suffering. Her attorney was methodical and effective. He produced physical therapy records spanning 8 months. He brought in a vocational expert who testified that repetitive kneeling, a staple of floral installation work, would likely cause the florist ongoing discomfort for years. A former client took the stand and described watching the florist wince through a bridal shower setup just 6 weeks after the fall. The jury was sympathetic. The florist cried twice during testimony, both times quietly, which somehow made it worse. The doctor's defense was straightforward. The floor had been mopped that morning. Yes, but it had been dry for nearly 2 hours by the time the florist arrived. His office manager testified that the cleaning crew finished their rounds before 8 o'clock. The appointment was at 10:15. There was no wet floor, there was no negligence. What there was, the defense argued, was a woman who had tripped over her own feet and then constructed a narrative around it. They called it a sympathetic accident. They did not call her a liar, not directly, but they didn't have to. Then came the footage. The building's exterior camera, a wide-angle unit mounted above the front entrance, had been subpoenaed as a formality. Nobody expected it to matter. It captured the parking lot, the front steps, and the sidewalk leading to the door. Standard footage, routine. Except that it also captured the florist arriving that Thursday morning. And it captured her leaving her car. And it captured her walking, briskly, confidently, across the parking lot toward the entrance. And then it captured her foot catching the lip of the front step, not the hallway floor, not a wet surface. The front step, the same step she had successfully navigated on 4 previous visits. She fell before she ever entered the building. The defense played the footage twice. The second time, the courtroom was completely silent. The florist's attorney requested a brief recess. When they returned, the argument shifted. The step itself was uneven, perhaps a separate liability. But the theory had already collapsed. The injury, real as it was, had not occurred inside the doctor's office. It had not occurred on a wet floor. And the narrative the florist had carried into that courtroom for 8 months had just been dismantled in 40 seconds of parking lot footage. The judge ruled in favor of the defendant. Full dismissal, no damages awarded. Court costs were split, an unusual outcome that some legal observers interpreted as the judge acknowledging the florist's genuine injuries while refusing to reward the misdirection. In the weeks that followed, the florist lost 2 vendor partnerships and her listing with a regional wedding directory. Her attorney quietly stopped returning calls from the local press. The doctor returned to his practice. His waiting room still smells like lavender. The florist's injuries were real, her losses were real, her suffering, by all accounts, was genuine. She simply pointed the blame in the wrong direction and then kept pointing even when she had the chance not to. Which raises the question worth sitting with. If someone is truly hurt, but dishonest about how, do they deserve any sympathy at all? Or did they forfeit that the moment they chose a story over the truth?